Okay, I'm prepared to go forward. This is the case number 200000095 MM. Fair and Equal versus the State of Michigan. This is a hearing on a motion for preliminary injunction. If counsel could please join and state their appearances. Counsel, if you would unmute yourselves, thank you. On behalf of the plaintiffs, would you state your appearances?
Gary Gordon, appearing on behalf of the plaintiffs with Steve Lytle of Dykema.
Thank you, Mr. Gordon. We can unfortunately not yet see you.
Yeah, I don't know what is happening there.
Gary, this is Steve Lytle. You may need to join the video if you can hear me.
Okay, now we can see you. On behalf of the defendants, please.
Good afternoon, Your Honor. This is Eric Grill with the Michigan Attorney General's Office, appearing on behalf of the state defendants.
Good afternoon, Your Honor. Heather Meingas from the Attorney General's Office, also appearing on behalf of the state defendants.
Okay, again, we are doing this via Zoom. If at any point in time, anyone has difficulty hearing something that is being said or seeing anything that is being demonstrated, please let us know immediately by raising your hand or whatever else you need to do in order to get our attention. Our court reporter, similarly, if at any point in time she cannot understand anything that's being said, will interject herself and make herself known so that we can take care of that problem. As you know, we are both on YouTube and live streaming. To make our process go forward, I would ask that everyone except the speaker and myself mute their microphones until such time as they are going to address the court. This is a case in which Fair and Equal and two named legislators have filed suit against the state of Michigan, Secretary of State, regarding the signature requirements for an initiative petition, including the date on which the signatures are to be filed, the number of signatures which are to be filed. They filed both an as written and an as applied challenge. They file these challenges under the Michigan Constitution. The defendants have had the opportunity and did rapidly file a response, and the court is very appreciative of their extraordinary effort in filing a brief in such a short period of time. This is the date and time set to determine whether or not the temporary restraining order issued after hearing, which continues until tomorrow, shall be transformed into a preliminary injunction, shall be dissolved, or whether or not the court will grant other relief. Who is, Mr. Gordon, are you going to proceed first?
Yes, Your Honor.
Please do so.
Thank you. And again, thank you for expediting this matter and scheduling the hearing so quickly. We truly appreciate that. I know Your Honor has indicated in our previous hearing that you are very familiar with the parties and the position of the parties with regard to what they were seeking through their ballot proposal. So I will skip those introductions and get right to the argument. Article 2, Section 9 is the provision providing for initiative. It's an article of the Constitution that is a reserved power to the people. It is to be liberally construed according to the case law to effectuate the ability of the people to initiate laws and to engage in the referendum. The legislature, the article has been deemed to be self-executing. The legislature's role is simply to implement the provisions of that section, not to hinder the operation of of the initiative or to regulate it in any fashion. In fact, this court recently, in League of Women Voters versus Benson, struck down an attempt by the legislature to require signatures to be obtained based upon congressional districts. And you stated, indeed, the geographic restriction in PA 608 undoubtedly limits, impairs, and hinders citizens' ability to engage in the constitutionally authorized initiative and/or referendum process by limiting circulators' ability. Similarly, here, because of the worldwide pandemic, statements by public health officials and state and local prohibitions against gathering and travel, the ability of the plaintiffs to initiate legislation is guaranteed by Article 2, Section 9, was and is unconstitutionally impaired. We don't contest the appropriateness of the statements of the limitations on gathering and travel as necessary to protect public health and safety. In fact, the Attorney General, in defense of the orders, executive orders, and at least 3 suits filed in the Court of Claims, has noted that the unprecedented emergency nature of the pandemic requiring that the application of various laws be truncated and that certain laws be limited because of the pandemic. The defendants have apparently abandoned this position in the instant case, but a review of their position in those cases clearly supports the plaintiffs here. We are asking that under the unique, unprecedented circumstances of this matter, that the application of laws be conducted in order to effectuate and to provide for the exercise of the constitutional authority for initiative. It's settled law that, and we cited a number of cases, I'm not going to repeat those in the quotes because I know your honor is familiar with them, that this right, again, must be liberally construed in favor of the people to exercise those rights. The instant petition, the fair and equal ballot proposal, was approved by the Board of State Canvassers, on January 28th. It initially had, and this is all memorialized and attested to in affidavits attached to our pleadings. It had great success in getting signatures, fundraising, expression of support across the spectrum. And in fact, the polling showed approval of over 77% of likely voters. Only one day after it had announced the collection of 100,000 signatures and that it was on time, on budget, and signature quality, the Michigan Department of Health and Human Services identified the first 2 positive cases of COVID-19 in Michigan. That was on March 10. State and local officials then cautioned.
Counsel, I deeply appreciate your underscoring the things that you wrote in your brief and the things that you said last week. Probably as important as those are, and no doubt as true and sincere as you are in your advocacy, we would make better use of our time if you looked at the things, those new aspects. I understand that you were moving forward. I understand that at a point in time, you made an attempt to use the mail, and that did not prove particularly productive. I understand that you perceive that if you were given a certain period of time under more ordinary circumstances, that you would be successful in achieving the number of petitions. But could you address some of the more particularized issues that were raised in the response?
I will do so, Your Honor. Thank you. I would note that, and I appreciate that you're familiar with the underlying facts as supported by our affidavits, because many of the statements I was making and the statements in the affidavits go to the defendant's claim that this matter should be barred because of latches. And I intended to demonstrate the diligence with which we operated in seeking signatures, the success we had, and so on. But since I appreciate that you're very familiar with that. I will pass on that. Your Honor, the application of two of the restrictions in the election law directly impact us. One is the 180-day limit. This is the statute that was enacted in 2016, which precludes the validity of any signature obtained outside of a 180-day window. Before that, it was not conclusive. The statute provided that there was a rebuttable presumption that signatures obtained out of that window period were not valid, but the presumption was able to be rebutted by affidavits and so on. In 2016, everything changed. We don't think that that change is directly necessary for adoption and implementation of the election laws, which is the only permitted purpose, and that it in fact acts as, in the circumstances of the present case, an undue restriction on the ability of our clients to circulate petitions. The second statute is MCL 168.471 and the 160-day requirement that triggered the May 27 deadline. That deadline did not exist until 2000. From 1963 until then, things operated without that mandatory statement.
Counsel, understanding that we understand that the law has changed and that the deadlines were imposed within this century, what tests do you ask this court to apply in determining whether or not there is a legitimate state interest in those two deadlines and whether or not it severely impacts your client's access to the ballot?
Thank you, Your Honor. In the limited circumstance of this case, as applied in the unique circumstance in which we find ourselves, the verdict test applies. Strict scrutiny of this because these two statutes together act in the current situation as an undue burden on the ability of the citizens to exercise their right to initiative. Now, this was recognized already. I know this is not binding on you, but it was recognized by United States District Court Judge Berg in Ishaki versus Benson. We've attached copies of those cases for your review to our briefs. Now, Ishaki was not mentioned at all, I note, in the Attorney General's brief. But as Judge Berg, gathering signatures in ordinary circumstance is a high hurdle. Judge Berg noted that these are not normal times. We did everything we could to collect the signatures on a timely basis. A number of courts have found that similar restrictions on circulation of petitions, and including the number of petition signatures required under the circumstances of these times, are unconstitutional. That happened with Judge Berg, and it was affirmed by the Sixth Circuit Court of Appeals. We cited other cases which indicated, let's see, Libertarian Party of Illinois versus Pritzker. The court found, and I quote, the combined effect of the restrictions on public gatherings imposed by the Illinois, plural, stay-at-home order and usual in-person signature requirement is a nearly insurmountable burden. There are other cases we cited that even gave up the signature requirement for nomination to office. Now, what is superimposed over these, Your Honor, and why we have an even more compelling case is the fact that running for office isn't a constitutionally protected right. Initiating legislation in Michigan is. So those cases are applicable to our situation, only more so. Well,
counsel, you want me to go Anderson Burdick, and I understand that. There are two possible analytical frameworks. One is strict scrutiny, but that is only if I find it's a severe restriction. If I find that it isn't a severe restriction, albeit a significant restriction, I would not be applying strict scrutiny.
No, you would be applying intermediate scrutiny, I believe, Your Honor. And even
Mhm.
under that standard, it is clearly unconstitutional. It prohibits us flatly and absolutely, under the unique circumstances we have in the instant case, from gathering signatures to initiate legislation. That's a constitutional right, and the constitutional right is being burdened by as applied here to prevent us from acting in that fashion.
Okay, so the state has you would agree the state has a regulatory interest in making sure that its elections are conducted in a way that is fair. You'd agree
Correct,
with
Your
that,
Honor.
I'm sure.
Yes, I do, Your Honor. I
And
represented
part
this
of that
case.
includes going through those signatures from whomever submits them to ascertain whether they are both sufficient in number and valid. Your colleague has presented to us a timetable that is their presumptive timetable, and trust me, they're going to be asked some questions about it. But looking at that timetable, it would appear that they are saying that they have a rational basis for saying that they need the amount of time between the filing deadline of the petitions and the day that a petition is actually voted on by the people, or more importantly, presented to the legislature, not more importantly, but earlier, presented to the legislature for review.
Correct, Your Honor, but the ability of the inconvenience to the state is certainly overcome by the exercise of a constitutional right. And I think it's significant that these two acts were not adopted until 2016 and 2000. So we had a period of time from 1963 till then that the election officials were able to do their jobs without unduly burdening their system and without unduly impairing the administration of the laws. But Your Honor, we have also posed alternative relief. And the alternative relief we are suggesting totally overcomes this kind of objection that the election officials might have. The alternative relief deals with the application of the 180-day time period. We are suggesting that that 180-day period be stayed for the period of time that public gatherings, person-to-person contact, and so on are prohibited, and then begin running again at the time that that is lifted, so that the plaintiffs will have a total period of time of 180 days to circulate their petitions, but they may not be filed under that scenario until before the election of 2022, which is the next general election at which the proposal can be voted.
So you would have me enact something that says that 2-year-old signatures are presumptively valid. That's really what we'd be saying at that point.
We would, well, I think the court in the Citizens for Fracking kind of has gone there already, where the petition signatures were gathered over, or they are 2 years old or more than a couple of years old, but they are limited to having been gathered within a 180-day window. So even though that these petitions may be older, they will have been gathered within the specific statutory time frame required by the election law.
Counsel, does it matter when your clients chose to begin their collection of ballot signatures?
No, our clients, I think, requested in December that the Board of Canvassers meet to certify their petitions, and they were not able to get a meeting together until late January. That can't be held against them by the state. But even though their petitions were not approved as to form, which is required before circulation can begin, they were on track, according to our affidavits, in ordinary circumstances, absent a pandemic, to file adequate valid signatures with the board on May 27 in order to qualify for the ballot. So no, I don't think that matters. And in fact, that specific issue was addressed by Judge Berg in a Shaki, where he indicated
Was
that
Judge Berg, I just want to make sure. I know that Judge Berg considered the Michigan Constitution, but I thought that Judge Berg ruled on the United States Constitution.
That's correct, Your Honor. He ruled on the U.S. Constitution, and but he could certainly considered the Michigan Constitution. Now, our counts 2 and 3 of the complaint are dealing with other sections of the Constitution, dealing with equal protection and due process. And Michigan case law states that analysis of those sections is coterminous with analysis of the United States Constitution. So that analysis would be equally applicable to our complaint, our additional counts.
Compared to whom are you being denied equal protection?
We are being denied equal protection of some other ballot question committee that would circulate this in absent the pandemic times. We're being denied due process of law also.
So you're being denied equal protection as to mythical projected persons, which is not likely to be real persuasive. Talk to me about due process.
Well, Your Honor, if you look at, again, I hate to keep referring to the federal court, but those arguments were raised and rejected by the federal court, by the defendants, is my understanding. That they're, well, if I may, Your Honor, let me grab my
There were
note
clearly
here.
other persons who might.
I'm sorry, Your Honor. You know, I misspoke about equal protection and due process. Our articles, Constitution 1963, Article 1, Sections 2 and 3 are free speech and freedom of association, not due process and equal protection. And the court, the case law said that they are coterminous with rights under the United States Constitution's First Amendment and freedom of speech. And Judge Berg there used verdict to perform the analysis. We have not disputed whether the defendants have an interest in the appropriate application of election law, the administration of election law, but the way it is operated in these current circumstance is that it has impaired our ability to exercise our right under the Constitution. And because of that, we believe this strict scrutiny applies under the limited circumstances of this case.
I understand.
All right. Thank you, Your Honor. So the argument that we could have been collected, we don't think it's not valid. It's not applicable here. In fact, Judge Berg said the argument with regard to the candidates was not when they began collecting signatures, but whether were they collecting signatures at the time the pandemic restrictions were put in place. And the answer was yes, and that's the operative date. But there is no valid basis to state that our clients acted in any manner other than aggressively and expeditiously seeking signatures, seeking fundraising, and so on.
If it gives you some solace, I can tell you that Latches is the worst of their arguments.
It gives me a fair amount of solace, Your Honor. Thank you. Okay. I won't. The lack of undue delay and so on is explained in our pleadings, and there's no prejudice by any alleged lack of delay to the.
You can't stop yourself, right?
I can't, Your Honor. But I just have to point that one out. So, Thank you, Your Honor.
Do you think you may want to comment, however, on their assertion that others have been able to gather what are ostensibly the required number of signatures?
If others were able to do so, and I don't know that the Board of Canvassers has certified any.
We're not saying, I said
as yet.
ostensible.
Ostensibly, all right.
Right.
Well, that's a matter of timing and when they began their process. There's no requirement in the law that the gathering of signatures has to take place so many days before they're filed. The requirements are they have to be filed 160 days before the election, and that they have to be gathered at least within a 180-day window.
Okay, I understand.
Yeah, and again, Your Honor, our affidavits that are uncontested, and the state admits that they are not able to contest the facts that we've asserted, are that absent the pandemic, we would have been able to file adequate signatures on time.
Okay.
And that's what the record shows, and there's nothing to contradict that. Now, Your Honor mentioned standing of the legislators. The defendants.
You're going to address the standing of another party?
No,
Okay.
we are representing two members of the legislature, Your Honor.
I thought that, okay, I was a bit confused. I thought that Mr. Liedl was representing them and you were representing the petitioners. Please excuse me.
Thank you, Your Honor. No, we are both representing both parties.
So that means that you're doing all of the oral argument, and is that correct?
Well, if yes, except I would invite Mr. Liedl to comment if he believes I've left anything out, Your Honor, if that would be acceptable to the court.
You might. But when you tell me that you're representing both parties and you begin the argument on their behalf, I would anticipate that two fine lawyers like yourselves will have collaborated and that you will say all that needs to be said, except perhaps he'll do the rebuttal.
We have collaborated a great deal, Your Honor. Thank you. Now, all right, and I will address the legislative standing if Your Honor so desires.
Please.
However, I would note that the defendants have not raised that. So it's deemed waived on their part, but I understand the court can bring up standing on its own motion at any time. So we'll address. There's no statute that specifically addresses this kind of standing. And when there isn't, the courts look at the substantial interest of the parties. Senator.
Counsel, so we're real clear. As individual petition signers?
As both individual petition signers and as legislators were being denied the opportunity to vote on the initiated law.
As individual petition signers, I have no question about their standing, which is what I'd said before. I was curious about their standing as members of the legislature, individual members of the legislature.
Thank you, Your Honor. I will address that. They have a special injury or right as recognized in DODAC versus State Administrative Board. In that case, there was a challenge by 4 members of the legislature to the authority.
Oh, counsel, come on now. In DODAC, the only person who got standing was the approach member. And that was a circumstance where it wasn't speculative that the ballot issue would get to them. There was an appropriation on which the legislature had voted. And the State Administrative Board chose to act in a way contrary to the affirmative vote of the legislature. In this case, we have 2 persons who would have the opportunity to vote if the right number of signatures are gathered, and if those signatures are valid, and if the question is certified and presented to the legislature. That's a long way from DODAC.
It is a a bit of a stretch, Your Honor. However, these legislators would have had, if we were allowed to continue with the petition circulation without the COVID crisis, according to our affidavits that are uncontested, we would have been able to file an adequate number of valid signatures to have it referred to the legislature for their 40-day period. Now, it may be, you may call it speculative, but the only evidence in the record is that we would have been able to come up with a number, the appropriate number of signatures to place it before the legislature. If we
Counsel,
assume
I
that-
absolutely agree that to the extent that your affidavits are based upon firsthand knowledge and facts, they are uncontested. The fact that one files an affidavit with a speculation doesn't make it any more factual than otherwise. There are aspects of your affidavit that are factually uncontested. The sincerity, the speed at which your clients were moving forward, the difficulty that they encountered, occasioned first by the pandemic itself, subsequently by the stay-at-home order, the fact that they utilized alternative means to collect signatures in a way that was an investment in time and money. Those are uncontested facts. Their perception that they would have been able to get the number or projection, a valid number of signatures, I can accept a rational inference that they would have gotten a number of signatures. I don't know that I've seen anything that would allow me to find that there is a factual basis for them determining that those signatures would in fact be valid. I've had the joy of filing petitions over and over and over. And even the best paid and honest ballot circulators end up with people who have misrepresented to them. So I agree that you have affidavits that are uncontested as to the facts. But I still don't see that this is beyond speculation, that either the senator or the rep would have the opportunity to vote. But I appreciate your argument.
Your Honor, I hesitate to, I won't say argue, but to add that the affidavits were demonstrating how many signatures per day were being gathered.
And again, I said, the rate of signatures. Validity? I don't know.
I would argue that it's speculative to assume that they aren't valid. I believe
It's
the signatures,
speculative either way. We know they got signatures.
I think the signatures are, I won't press it, Your Honor. Should
Okay.
they have been filed with and determined to be valid, as our affiants truly believe they would have been, then these two legislators would have been denied, because of the COVID crisis, of the right to vote for a law initiated by the people. And that violation, if it's based on an unconstitutional application or as applied here, is a particularized individual harm adequate to give them standing as legislators, is our argument, Your Honor.
I understand.
Thank you. Now,
Thank you.
let me address the proposed relief, if I may. That
Okay.
it has,
We've been about 33 minutes.
thank you, Your Honor. I'll wrap up very quickly. The after we've looked at a lot of the concern raised by you and by the defendants dealing with administration of the election laws, and about the difficulty of or the bar in changing the number of signatures required by the Constitution. Now, we already know that the Secretary of State has modified existing law with regard to the number of signatures required for candidates for office, and also the filing deadlines. So as long as they recognize that authority exists in order to create an as-applied constitutional framework for the exercise of that right, we pose the following as an alternate. And it's because, you know, they've limited, you know, we have claimed a constitutional violation. I think we've demonstrated all the requirements for injunctive relief. The harm, which a lack of harm has been raised by the defendants, we don't think is a valid argument, because the case law strongly supports that if you reach the level that a constitutional right has been violated, then it amounts to per se irreparable harm. Once that is established, and everything else falls in place, including likelihood of success on the merits, and a balancing interest between inconvenience to the election officials as opposed to the exercise of constitutional rights, clearly falls in favor of the people. If we get to that point, Your Honor, then we are proposing that a temporary and limited suspension of the operation of 168.472A, which is the 180-day limitation, occur, and that it be suspended for a period of time extending from March 20 and ending the earlier of the date where no executive order or public health order restricts public gatherings in response to COVID-19 is in effect, or on January 17, 2022. And the reason that date was selected, Your Honor, is if we do the math, the remainder of days within the 180-day time frame extends from that date to the filing requirement of ballot proposals for that year.
Okay, I want to make sure I'm understanding conceptually. I'm not worried about what the dates are. What you want to do at the very least is get the same number of days as were remaining as of the stay-at-home order?
Or well, March 20th is the date, but yes, in general, because that is the date that the brakes were put on.
The brakes were put on, you're saying, by the stay-at-home order, right?
Correct. And well,
Or,
yes.
I thought because you had addressed other orders before stay-at-home, so that's why I want to make sure.
Yes.
I understand. Thank you. You'll have an opportunity to reply to your colleagues' arguments.
Thank you, Your Honor.
On behalf of the defendants, Ms. Meingas?
Actually, Your Honor, it's me today.
Oh, see, you switched up on me, just to confuse me. Okay, good.
Yeah. Not just to confuse the court, Your Honor. There's a variety of reasons. But thank you, Your Honor. I am well aware that the court has read the briefs, and so I will constrain my remarks to just a few things to respond to Mr. Gordon, things that were not perhaps expressly stated in the briefing. The thing that most captures my attention in this case, Your Honor, is that the burdens that the plaintiffs are alleging here are not actually those imposed by the election laws they're challenging. The laws were not changed in response to the COVID-19 crisis. They were set well in advance. Instead, the plaintiff's argument is that there's this combined effect of the laws and the executive orders creates this unconstitutional burden. That the executive orders, in effect, somehow curtailed their ability to gather signatures. But there's a problem there that I don't think that counsel has adequately addressed. First, they do acknowledge that there's no challenge to the reasonableness of the orders themselves. They acknowledge that there was a reason and a purpose for them. But the executive orders did not change any of the deadlines that are being challenged here, did not change the number of signatures required. It did not bar them from access to the ballot.
Well, counsel, let's pretend it's not an executive order.
Okay.
Let's pretend that there was a natural disaster that occasioned the failure of certain infrastructure systems within the state. That either, as we had a few in the last century, the electrical grid failed. Or we had other natural disasters, and that for a period of time, really basically nobody could go anywhere. Now, can you accept the fact that there are circumstances where ordinarily rational laws that were not intended for any discriminatory purpose can have an effect of depriving persons of their constitutional rights?
There are circumstances, Your Honor, or I think, but usually where that's applied is this, there's still an element of state action involved. In this circumstance here, what is it exactly that the state did that gave rise to the idea that these statutes are now unconstitutional? If it's the
So counsel, you want to separate the existence of the pandemic from the state action of the executive orders. And in your argument, you said in part that even if there hadn't been an executive order, persons of good sense would not be running about gathering and collecting signatures more likely than not. I couldn't figure out what difference that made.
Well, it's simply this, Your Honor, and where I was going with it was the difficulty in collecting signatures here is not the result of the deadline of May 27th. The difficulty in collecting signatures is not the number of signatures required. The difficulty they experienced in collecting signatures was not the result of the EOs. There's nothing in the EOs that really prevented them from circulating. I think even the fact that they didn't circulate, or that they didn't immediately go to the courts to say, there's this ambiguity, if there is any, in the executive orders that restricts us from being able to circulate. We have this First Amendment right.
So really, your contention was the section of the EOs that says this doesn't amend people, this does not abridge people's First Amendment rights, meant that they could have gone around in violation of the, in contravention of the executive order to stay at home, and still gone to places and approached persons because it was their First Amendment right and the rest of the EOs didn't matter?
Not that they don't matter, Your Honor, but that's exactly what it means when they say this does not abridge expressive activities, that they would have had the ability to do so. Now, whether there were people there at the malls for them to gather signatures, whether there would have been festivals for them to go
Well,
to.
the malls were closed, so we can pretty much eliminate that.
Well,
So
that's
they would
the
have
point,
been
Your Honor.
going around, they would have been going door to door to the houses of other humans.
Correct. And that would not have been, there are ways of doing that that still maintain the safe social distance, Your Honor. We've all been able, at least many people have still gone to the grocery store and maintained social distances. There are ways of doing that. It would have, there's not anything in the executive orders themselves that expressly says this makes it impossible to gather signatures. And it certainly doesn't say that it expressly bars the gathering of signatures. Mm-hmm. So what we're left with then is, what was it?
Is it impossible, or is the issue a severe burden?
I'm sorry, Your Honor?
Does the same severe burden analysis that we're supposed to look at in verdict apply here? In other words, whether the acts as written, the signature requirements, the deadlines as written were just fine, but whether or not the imposition of the executive order in light of the circumstance imposed a severe burden.
Well, I guess there still has to be, for the Anderson verdict to apply, we have to be talking about some type of regulation of the election itself. And I guess, and again, I guess my question still remains, what is exactly the regulation of the election that was imposed as a result of the COVID-19 pandemic? There's still some, there isn't any. What we have instead is the idea that the executive order interfered with their ability to collect signatures. It wasn't from the language of the executive order itself. It more or less comes down to the secondary effects of there being a pandemic. There were fewer people out and about and able to collect signatures. So the question becomes, what is the state action that interfered with the ability to collect signatures? And then it's not really clear to me that there is one. But if we're going to proceed with the Anderson verdict analysis, and we went through it in our brief, and I certainly will continue to rely on the analysis there, but in response to the argument raised by the plaintiff's counsel, if we're applying Anderson verdict, why would we reach a different result than the Sixth Circuit reached in the Thompson v. DeWine case, where they found that it was the same type of a thing where we had a challenge to a state initiative process, the state constitutional requirements, and the Sixth Circuit found that the burdens there were not severe, that there was a compelling state interest, and that it favored the states and upheld and basically sent it down to the district court. The district court got it wrong. don't enjoin this, don't change the deadlines. That's not what we're supposed to do. There was great deference shown to the state in that circumstance, and I would suggest that the same result should occur here. Turning to the proposed remedies offered by the plaintiff's counsel, I think it's again worth reiterating, and I'm mindful that the court suggested you had some questions about the timeline, so I'll wait for the court to tell me when you have one. The May 27th deadline is part of a larger framework for ballot approval. The 60 days that we have for canvassing are not just drawn out of thin air. That is based on specific circumstances. First, it takes time to canvass. I know the court's aware of that. There's a lot of signatures to count. There's a lot of things to do that are involved with that. But more importantly, that 60 days also includes the time for challenges to the signatures offered by the proponents and challenged by the opponents to the proposal. We have to resolve those before we can get it to the Board of State Canvassers in order for them to approve the ballot language and advance the ballot for certification. So when are we supposed to do that exactly? That as the court's well aware, challenges to signatures frequently are the subject of litigation. So we have to kind of have some time built into this and baked into the pie to allow for to resolve that process.
So you would agree that as you said, baked in to your schedule are potential, possible, therefore sometimes called speculative occurrences, challenges, litigation, etc. And so because you've got those kinds of things baked in, and prudently so, that probably means that there is some latitude in the time. And the question is, if there is some latitude, what is it that makes their July deadline more burdensome than the deadlines that you have?
So the July 24th deadline is at that point it goes to the state legislature for their 40-day conclusion.
No, I'm sorry. I'm talking about, they asked for an extension to July 12th.
Oh, July 13th, Your Honor. That would essentially leave us with 2 weeks. And I think at that point, there's no scenario I think that I can understand where that works, because when are there even going to be challenges? And I know that we haven't had a challenge yet, so I can't point to say that this person is going to have a challenge, but I would certainly submit to the court that anytime we're dealing with a statewide ballot proposal, there is almost always at least one challenge or another.
So your colleague suggested alternatively today that it is the 180-day validity that he would ask that be extended to a date to accommodate the period of time remaining in the 180 days at the very least, as of March 20th, if I recall correctly.
Correct, Your Honor. And I guess my question about that is, I think there are more questions raised by that than I think that have been addressed so far, and perhaps counsel can address some of them in the reply. The first would be, and I think the court already kind of touched on it earlier, was exactly when are they talking about filing? Are we talking about having these signatures canvassed and reviewed 2 years from now for the next election? If that's the case, how exactly are we handling errors and registration problems of the signatures? Are we going to go by when the voter is registered now, when they signed it, or 2 years from now when the petition is ultimately filed? And how do we reconcile the differences that there may be between those? People move, things change. People may no longer even live in the state by that point. I think there's also a potential risk of voter confusion if we have the same petition circulating 2 years later. Someone who signed it back in March could see it several months from now, or even next year, whatever it is that they're circulating the petition, and think it's a new petition and sign it twice, thereby causing a conflict and negating their earlier signature. I would also, and this is a specific question, but in light of the change to the executive order that was started yesterday, and the idea that we are soon to be having outdoor gatherings of 100 people are now to be permitted, does that sufficiently lift the restrictions, to borrow counsel's terminology, that they will start circulating now, or are they talking about doing so at some point in the future?
Okay. What more do you want me to know?
If the court has any other questions, I'll do my best to answer them.
I don't have any further. Thank you.
Thank you, Your Honor.
what did, I know it's, normally council could chat with each other or sit at a council table and make comment. So it occurs to me that given the fact that we don't have a chat line here between co-counsel, either for defense or plaintiff, I would give Mr. Little, to the extent that he wishes, the opportunity to share his wisdom, and then go back to yourself, Mr. Gordon. And I would ask, before I do that, Ms. Meingast, is there anything that you feel that you should share?
No, Your Honor, Mr. Grill covered everything.
Thank you. Mr. Little, is there something that you wish to state for the record?
Sure.
Your Honor, through the miracle of modern electronics, we've decided that Mr. Lidl should go ahead and do the rebuttal too. Well,
just like my students, you were emailing during the course of my class. So yeah, I'm used to that. Go ahead.
Yeah. Unlike in the context of a public bodies meeting, not in violation of the Open Meetings Act.
That's
Thankfully,
correct.
Mr. Gordon and I are not a public body. We'll take just a few minutes of the court's time, if that's acceptable to Your Honor.
Okay.
I wanted to respond to a few items raised by the Attorney General. First, with regard to government action, I will remind the parties and the court that the executive orders issued by the governor and the additional public health orders issued by the director of Department of Health and Human Services pursuant to public law actually restricted persons from leaving their homes except for authorized purposes. So for example, I could go to the grocery store if it was to purchase essential food for my family. I could not go to the grocery store if I was there to circulate petitions. Right? I could go to a factory if it was my job to work at that factory to perform essential services necessary to respond to COVID-19, but I could not circulate signatures at the factory gate. So,
Mr. Lidl, what you're left with there, though, is there is a section that says this does not constrict people's First Amendment. And we had religious institutions and others gathering and protesters exercising their First Amendment rights at the same time that there was a don't go anywhere unless it's essential for the preservation of human life and safety.
Right. We can see that, Your Honor, but we are not just talking about First Amendment rights here. Here, the people have reserved to themselves a separate and distinct right, the right to initiate laws by petition. And there were no such exceptions in any public health order issued by the department or the governor or otherwise, or in any restrictions that I'm aware of relating to public officials with regard to this separate and distinct right that the people saw fit to include in addition to the right. When the right of initiative was added to the Constitution, the right of the First Amendment and the right to exercise that was deemed insufficient as a check on the legislature. And for that reason, they added, and the people in a subsequent constitutional convention have retained this separate specified retained right. And I note that in particular, it is a retained right. Under Article 1, Section 1 of the Constitution, the people were clear. All political power is inherent in the people. They did that in the first sentence of the first article. What did they do in the second article? Before they created a legislature, before they created a judiciary, before they created an executive branch, they said that the people were reserving to themselves the right to exercise this specified constitutional right. It stands in addition to other constitutional rights. I would also note that in the same way, the state is claiming that it is entitled to deference in its regulation of elections. Because this is a right reserved to the people are the state under our Constitution. And they are entitled to deference by government actors when they are taking actions that restrict the exercise of that governmental right. So the state isn't, as the state is entitled to deference in certain areas in managing elections, the people are entitled to deference from the government because they retain this right in a way that the government could not interfere with it. And so I think that in addition to the restrictions on movement, I would also note, most importantly, for a statewide ballot proposal, it is important to be able to exercise the right of association, and this right in large groups in order to gather the signatures necessary to satisfy the requirements imposed by the state in terms of timeline and deadlines. The last thing I would want to note with regard to the Ohio precedent from the case involving Governor DeWine, we would note that that was applying unique elements of the Ohio Constitution and Ohio law that vary from the reserved constitutional right here and are inapplicable. We do note, as Mr. Gordon has noted though, the same arguments that the Attorney General is making today, the Attorney General has unsuccessfully made both before the United States District Court for the Eastern District and the Sixth Circuit with regard to the impact of state action, rightful state action, in response to the coronavirus and the circulation of petitions in the context of Michigan election law. Lastly, I think I'd like to point out that this court has held that a requirement to secure signatures in each congressional district, that alone is an unconstitutional restriction on the initiative rights. So the legislature, according to this court, may not constitutionally require the people to gather signatures in certain congressional districts. And that is sufficient to invalidate state law restricting the restriction here. We are only asking for a limited restriction, much more limited and not permanent, as the court has recognized in this case, caused solely by the coronavirus. And it's exacerbated by the interaction of both the coronavirus and related state actions and the 180-day requirement, which limits the ability of someone to gather the signatures. In the case of the congressional district action, if I can't get to that congressional district this week, I can get there next week. Here, there's a 180-day clock that's running. Had Fair and Equal Michigan known that the coronavirus were going to occur, they could have avoided the impact of that 180-day clock by not filing, waiting to see what the effect of the pandemic would be. Unfortunately, they did file, and while they were in the midst of gathering signatures at a sufficient rate, the state actions intervened, and there's nothing to stop the clock. So one thing, the relief that we would ask this court to focus on, because we do recognize, one, the burdens on the election process of going through the process of altering a deadline that would burden the administration of the 2020 election. And we do understand the high bar that's involved in suspending a constitutional signature requirement. We think that by focusing on essentially suspending the 120-day timeline while pandemic conditions persist and allowing Fair and Equal Michigan to restart that clock when the pandemic conditions and related government restrictions are gone, that would be an appropriate remedy in this case, given
Counsel, I understand 180 days running from the beginning and imposition of state action till the end of state action.
Yeah.
I don't understand till the pandemic resolves. Unfortunately, the public health people tell us we don't know when it's going to resolve. We do not know when it's going to reaffirm. So I would indicate to you that the probability that I would give you any order that says until the COVID-19 situation is reasonably resolved is slim and none.
We appreciate that, Your Honor, and we're not asking for that. We're asking that that the timeline be told until any state restrictions.
State restrictions?
Yeah, state restrictions on public gatherings remain in effect.
Okay, so you want me to give you an order that says until there is no restriction on zero on gatherings. That would also include not only the number, the distance, the masks, the difference between indoor and outdoor. Do you really mean that?
No, let me clarify, Your Honor. Not with regard to any other restrictions, only to the extent that there are still state orders restricting the gathering of persons in certain numbers. That would be the trigger, because that's what's most important in terms of exercising this constitutional rights, is that you can interact, associate with persons in large groups and secure signatures.
It's 100's not enough for you.
No, Your Honor, the most important place where you can secure these signatures, this is not a local campaign to qualify someone for the ballot with a few hundred or 1,000 signatures. We're talking 340,000 signatures. Those are most
I understand the
effectively-
number. You believe that I should say until there is no restriction whatsoever on the number of persons gathered.
We're happy
Okay.
to propose a number, if Your Honor. We can propose 7,500 or
I heard what you
5,000.
asked for.
Yeah, we'd be happy to propose a number. The main thing are large gatherings at schools, athletic events, festivals, music events. Until the restrictions on those activities are lifted, the ability
Council,
to exercise-
social distancing is going to restrict we don't even know when schools are opening.
Correct.
We don't know how they're going to open. So this would be like some ad infinitum floating deadline.
We're not asking for an ad
That's not what
infinitum
courts
floating
do.
deadline. Yeah,
But
we're
it
not
is.
asking for that, Your Honor. We're asking for that, and then we would also set a hard date, even if restrictions aren't lifted in January of 2022, for the clock on 180 days to be
Okay.
started.
I understand.
So not an infinite, just a temporary to essentially allow the Fair and Equal Michigan proponents to circulate when government restrictions aren't in place. They are able to handle masks and other restrictions on social distancing, the problematic governmental restrictions.
Counsel, you are asking for a relief that has never been presented to your colleagues. Is that fair? Mr. Gill?
I know, Your Honor, I think that's consistent
I'm
with the
asking Mr.
alternative.
Gill. Has this relief that he just spoke of ever been presented to you?
I'm sorry,
Are we even sure what it is? But whatever it is, has it been presented to you?
if Mr. Liddell could repeat it one more time, Your Honor, I'm not sure I heard it completely.
Consistent with the alternative relief proposed by the plaintiffs in its original complaint, we would ask essentially that the 180-day period be tolled until restrictions on state government restrictions on public gatherings are removed, or an earlier date of January of 2020.
Okay, now just in all fairness, when you were talking, you modified that a little bit because you said not restrictions as to number of persons gathered. Isn't that the modification you made?
We would be comfortable with a restriction on numbers of persons, Your Honor, if it were, large enough to permit, 5,000, 7,500 large gatherings where these petition signatures typically are gathered. Festivals, we do have certain state universities that have announced the reopening.
This isn't getting clearer. I want to get it clear.
Okay.
You are asking that you want this listed until 5,000 people can gather or January 2021.
Yes, the date in January would be, I'll give you an exact date, Your Honor, so that we want to make sure that Fair and Equal Michigan has
Just
no
give us
more
the
than
date. Please don't, because the more you talk, the more confusing this gets.
All right. So, Your Honor, the date would be January 17th, 2022.
Okay, now I'll go back to you, Mr. Gill. Has that request for relief ever been presented to you?
Your Honor, I guess I'm a little reluctant to get too, I'm aware of the constraints of MRE 408, and I don't want to get into settlement negotiations.
Has it been presented to you in the context of this litigation in writing so that you could give a formal response to it?
I'm not completely certain, Your Honor. In fairness, there's been a division of labor, and I wouldn't necessarily have been the one making any of that type of specific
Ms.
communication.
Meingast, has this ever been, never mind. Here's what we're gonna do. We're gonna make life easier. On behalf of the plaintiffs, please present this request for alternative relief in writing by 5 o'clock tomorrow. That would give the defendants, to the extent that they wish to give a written response to that specific request for relief, until 24 hours after that, which takes us to Thursday, so that at least whenever I rule on this, I can say you fairly had a chance to consider it and give me whatever you want me to know about it until the Court of Appeals overrules me? Are we good? Okay. The court has issued an injunction which would have by its terms expired tomorrow. I'm going to have it expire on a week from today at 4 o'clock because you need to have a written opinion. And I have 18 cases on case call on Thursday and Friday. Who can prepare the extension, please?
We will do so, Your Honor.
Thank you very much. Is there anything more that we need to say for the record on behalf of the plaintiffs?
No, Your Honor, thank you. Should we, one thing, should we provide you a copy of the proposal also?
Yes, if you're filing with, you file it with the court. Serve it on your colleagues, file it with the court. So it will be part of the court record. I'm sorry, I spoke imprecisely and that was inappropriate.
My own confusion, not yours, Your Honor. Thank you.
On behalf of the defendants, anything further?
I have nothing further to add, Your Honor.
So you'll see, what I trust is this extension will not be like a big boo-ha-ha. Somebody will draft it, you'll sign off on it, I'll sign off on it. It's not saying you agreed to it, it's just saying this is what the court said should happen. Okay.
I
Thank
understand,
you.
Your Honor.
Thank you very much. With that, we will conclude the hearing.